Good morning. Are you Leonard Gillery? And Mr. Gillery, in cause number 22-40982, on probation for unlawful possession of a firearm by a felon, that probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
It was with a vehicle. That's at least what the administrative hearing says, but
I don't know that it was with a vehicle.
I haven't seen anything about the evading.
I think
it was only the.
My recollection was that it was evading on foot. I'm happy to explore it and check.
that's okay. Let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. And the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response, reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. It allegedly
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
No, ma'am. Judge, it's just arguments.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Gillery had, it seems that he was doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process of taking care of this case. So he definitely would like that opportunity, at least by having a bond set on with the MTRP. As far as the new case with the ag assault, understandably, it is would be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions that may secure any of the court's concerns with any public or private safety for the complainant witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today and has been here each time before she would come to court. And so that's what we ask for, Judge. Just, if they can get a bond that is a little more reasonable than $200,000. A bond that high, a lot of bonds from the courts It's hard, a lot of them won't even touch that amount.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or they've been going to court on that, my understanding. So the main issues that we were dealing with, of course, is what was here.
Well, that's, obviously that one is also important to me because that would be another felony allegation while he's on this probation. Let me see if the administrative hearing has any information on that.
Yeah.
So when the administrative hearings are scanned in, I've noticed that some of them, it'll say see attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should have
Court copy,
it.
because it's not public.
Gotcha.
I'm sorry, Judge.
No, that's perfect. That's what I needed. Give me a second. I'm gonna print this out because this is. Mine.
Oh, I'm sorry.
So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offense of burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So this is allegedly a neighbor where the allegation is that Mr. Gillery got in their car, tried to start it and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, he said this was an episode where he was under some type of psychosis, dealing with mental health, and checked himself in for treatment shortly after.
All right, so obviously I need that information because I don't feel like if that's going on that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. based on all of the allegations in the motion as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful possession of a firearm by a felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on all of that information, under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know and we'll get someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff. And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there it was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the decision will be very easy.
I've already know what I'm going to do, but I'd be glad for you to do that as well.
Your Honor,
ahead.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. I want to see what the bond is set at on the new case, 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So, Ms. Holmes, any,
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you need to behave in jail?
No, man.
This is ridiculous. These people are just going to work and trying to do their job. That's all.
Yes, ma'am.
You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. You think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient, and in that case I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device, and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition in cause number 25 DCCR 0738, to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janaisha Butler.
Janaisha Butler?
Jamaisha.
Jamaisha.
JamayshA.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a sentencing, for an announcement.